let's dive right in here. And I talk to people all the time. I'm sure you do too, Tom. You know, they're like, this tenant has paid in 6 months. And I think I got to start the legal process. Now, I can confidently say that is the wrong approach. But I also get people, it's like day 6, I deliver 5 days. Should I file? I think that's too aggressive an approach. Like, what do you recommend to your clients, or what do you see as being a best practice kind of from your point of view when it comes to like, I got to serve a 5 day to actually really potentially go after the legal part of this?
So we actually recommend serving a 5 day after the grace period in the first month of unpaid rent has passed. So if there's a grace period of the 5th of the month, serve your 5 day on the 6th of the month. If it's the 10th or the 15th, serve your 5 day the day after the grace period expires. Do this consistently with all tenants who have not paid. I understand some tenants will tell you, we're coming up with it. We'll come up with it by the end of the month. But it's really important to have a consistent policy in place. Okay, I understand you guys are going to come up with the money, but it's my policy to serve a 5 day notice after the grace period has ended. So I am going to serve you with the 5 day notice, just like I serve everybody. The consistency, one, is going to protect you from discrimination complaints, which is always really, really important, especially in Cook County and Chicago. And you also get a nice, consistent feeling back from your tenants. This landlord is serious. This landlord is always going to serve the 5 day notice. I'm not going to get a free month. And that kind of spreads among your tenants, and it actually encourages payment in the future. You just set up a consistent policy across the board, and tenants kind of start falling in line, and you will end up getting more consistent payment if you consistently put out 5 days. Now, for filing, if you have tenants who are saying, hey, we can pay by the end of the month, I'm not saying you have to file your case immediately after the 5 day notice has expired. If you're working out payment plans, if they're telling you you're going to pay, you can make the decision whether to file on that 5 day notice once it's expired or give the tenant a week or 2 extra.
Breakdown, we'll go very 101 here. A 5 day notice. When you are delivering a 5 day notice, what is it and what are you really doing to those? What are you saying, I guess, in that message?
And do you have to physically deliver it to the tenant?
Yeah, I was going to go on that too. Like, talk about process server versus physically versus posting. Give us kind of that spiel.
Yep, absolutely. Absolutely. So we refer very generally to a 5 day notice as a termination notice for non-payment. So when your tenant hasn't paid and you want to terminate their tenancy for non-payment, you have to serve them with a written notice. We use 5 day because Illinois statute says the minimum amount of time you can give a tenant to pay is 5 days. I always caution clients, landlords who use a lease that might be off the internet. It's not one of the standard leases. They're, multi-state, and they're using their lease from Indiana in Illinois. Leases that are not in compliance with Illinois law could say you have to give your tenant 7 days or 10 days to pay. Some even say 3 days, but it's 5 days in Illinois unless your lease says more. So just be careful. Always look at your lease and make sure you can use a 5 day notice. I'm going to use that term just because it's the standard, what we talk about in Illinois, but I'm throwing that caveat out there. So a 5 day notice is going to tell the tenant how much they owe and give them 5 days to pay in full. You got to have the tenant's name. You got to have their full address. Write the word street or avenue. Make sure the unit number and the zip code all included and have the proper address in there. You want the amount that's due through the date you sign that notice. So make sure the full amount of rent is due. In Chicago and Cook County, you should only include rent. You should not include late fees or repair charges or utilities unless your lease says that those amounts are considered additional rent. Judges do not like to see landlords throwing in every different amount due. They only want to see rent. So that's a little lease provision tip there. Your lease should say that everything that the tenant has to pay is considered additional rent. And then you can throw everything in the kitchen sink into your 5 day notice. So we've got tenant name, full address, the amount that's due. it has to tell them that they have 5 days to pay. Then there is some statutory language in Illinois that says to the effect of only full payment will waive the landlord's right to pursue termination of your tenancy. But it's very specific statutory language that has to be included. So don't pull a termination notice off of, a website for California notices. It's got to have this Illinois statute language in there. And it has to be dated and signed by the landlord. Now, there's some other technical issues that tenants' rights attorneys sometimes bring up. I've had arguments that the 5-day notice should include where payment can be made. We have generally overcome those arguments, and the judge agrees that if the tenant has been paying rent regularly, they should know where to pay the rent. So just be careful. Another argument that has been made is whether the person signing is actually the landlord or an agent. Is the landlord identified on the 5-day notice? We have overcome those arguments as well, but it may be good under the landlord signature line to either put ABC Management as agent for owner or the ownership ABC Property LLC as the landlord's name. So just a few technical requirements. So that's what needs to be included in the 5-day. Really, really important. I'm glad you guys brought up service, because service of a 5-day notice in Illinois, especially in Chicago, is really, really important. So Illinois statute says you have to serve by personally handing it to someone, either the tenant or any occupant who is 13 years or older, sending it by certified mail, or posting on the door if no one is actually in possession of the unit. So let's talk about those first two. You can hand it to the tenant. That is the best way, absolutely, to serve a 5-day notice. You can hand it to any occupant who lives there who's age 13 or older. So, if the tenant has a 13-year-old son, you can hand that 5-day notice to the 13-year-old. Certified mail. Judges want to see a green card with a legible signature of the tenant. Those are very hard to come by these days. Not only is it really difficult to get the green card back, when you get it back, there's some scribble on it and you absolutely cannot make out who signed it. And the judge is going to say that's not proper service. Last is posting. And this is the one that gets landlords all the time. I hear, it says I can post it. No, it says you can only post if no one is actually in possession. So the statute requirement is that you can only post if the tenants have abandoned the unit, but they left a bunch of stuff in there and you want to be, really safe and go the eviction route, but they're not living in there. Then you can post it. Otherwise, you have to try to personally serve the tenant. In Chicago, I've had judges say, you could sit outside that unit 24/7. I bet you'd get him. Can't post it, need to personally serve it. The judges are really, really sticklers for personal service. So our general rule of thumb that we tell clients is 8 to 12 attempts at personal service. Write down the date and time that you made those attempts and what happened. You heard the TV inside, nobody came to the door. The tenant's car's in the driveway, nobody came to the door. Dog barking, nobody came to the door. After those 8 to 12 attempts, then post it, mail it regular mail. If you have an email address for the tenant, email it to the tenant as well. Then from our office, we have our clients sign what's called an affidavit of due diligence, where we are having the client testify in an affidavit as to all the different service attempts they tried. When we do that, we've been very successful. We have not had a case dismissed for posting when our client has followed all of those rigorous requirements, but it is time consuming. But I will tell you, absolutely in Chicago, if you post a notice without attempting personal service, the judges will dismiss your case. As soon as they catch it, they will dismiss your case. They want to see the notice before they enter an eviction order, and they will catch it, and your case will be dismissed. So that posting gets landlords but in Chicago and Cook County, make sure you are attempting personal service at least 8 to 12 times before you post.
Yep. So a couple random questions here about servicing. This is all great information, Jessica. I've heard landlords do the, serve the notice to enter, like, hey, I'm coming in 48 hours. Like, here is the, whether it be email, slide under the door, and then, knock, knock, I'm notice to enter, you've been given your warning, and try to serve that way. Do you see issues with that? And then also, I mean, what about servicing them outside of the unit? Where they were. I mean, this is getting like, pretty extreme, but like, are those other avenues if you have to go that route?
Yep, absolutely. So you can definitely give them a notice that you're going to access in 48 hours, and hopefully they will be there, and serve them with the notice at that time. Absolutely. I mean, there's nothing wrong with that. I have had management companies in big buildings, at the barbecue, they like give special invitations to the tenant that needs service, and, oh, make sure you're coming, we'd love to see you. And the tenant comes down and they serve them with the 5-day notice. I've had clients use package delivery when there is a package, but make sure they have somebody monitoring when this tenant has a package come in, and that person is standing there in the package room waiting to serve the tenant. So yeah, definitely you can use different methods to lure the tenant into receiving that notice. And second, yes, serving offsite is fine. The difference is when you serve at the unit, if there are 3 leaseholders on your lease, 3 tenants named on your lease, at the unit, you can serve one of those tenants and it counts on all of them. That's called abode service, or service at the dwelling unit. If you get one of them, it counts on all of them. If you are serving them offsite at their employment, you can do that, but it only counts on service on that particular tenant. So you would have to go to all 3 of their places of employment to get them served versus just serving them at their house. But if you've got one tenant and you know where he works and he's there from 6 a.m. till 9 at night or something insane, and you can't get him at the property, you could definitely serve him at his place of employment.
I got a buddy of mine that's got a newer building that has the fire system in there. He pulled the panel and alarm went out. He's like, I was glad to pay the $500 fine to the fire department, and I was able to get him served when they came running out to get the building was on fire. So
yep.
There's different levels of creativity.
Yep.
For the personal service though, what if you knock on the door and the tenant's brother answers the door and he's obviously over 13, and you hand it to them? Is that talk to us about that? Is that acceptable because they're over 13 and they're in the unit? Tell us more. It
has to be somebody who resides in or is in charge of the unit. So, it depends. If the brother's visiting for the afternoon, no, that's not going to be good service. If the brother is staying there indefinitely, as an unauthorized occupant, yes, that would be good service. So you kind of have to get a little bit more information from the person you are serving if it's not your leaseholder or an authorized occupant that you know of. You've got to know, how long are they there? Are they just hanging out for the afternoon, or have they moved in temporarily? Who are you? What's your name? Get as much information about that person as possible.
We've moved a lot more towards process servers because the amount of time they can put into it, the amount of information they give back, like they're pretty detailed, right? They talk to us about using process server. Is that, do people like yourself look at that as a positive?
Well, we do, absolutely. I think it makes life a lot easier. As far as going to court with an affidavit of service, your process server affidavit is always going to be more detailed. I think the judges, not that they don't give credibility to landlords who fill out their own affidavits, but seeing the same process server affidavit over and over, they know these process servers don't have a stake in the case, and it's just honest information included with all of the detail. On the flip side, there's a cost for a process server, obviously. And if time is really of the essence, if you're really, really in a time crunch, maybe it's a conduct case and you want to get a 10-day notice served as quickly as possible. When you use a process server, it's generally they get the first attempt in about 36 hours from the time. That's usually what the couple process servers we work with tell us, about 36 hours from the time they receive it, and about 36 to 48 hours after that, each attempt is made. So they're not going to your property every day. They're not going to go the same day that they receive it. So if you really want to get that notice served immediately, it's better off if you do it, because you're going to be able to do it every single day. If you are having problems serving and you got to go through that process of 8 to 12 personal attempts before you post, my clients don't want to use a process server because it's going to be like every 2 or 3 days that they're getting it, when our client could go every single day and make an attempt. So there are definitely pros and cons. Of course, as an attorney, I love to see an affidavit from a process server because it's very clean, it's very reliable, and it's.
I see a lot of landlords give up, or they'll get mad one day, they're gonna drop the 5-day, and then they never go do it. But I always tell them, just send it to the process server. Then it's there's no point of return at that point, and it'll get done before you get mad about it next week when you stop focusing on work or something like that. So sometimes it helps.
Either are you going to make it a priority or not, right?
Yeah,
if not, punt. If someone else
exactly.
Well, time too. Like if you're in the north side and you have a property on the south side, if you got to go another 2-3 times to find them, it's cheaper to pay the 85, whatever it might be, $75 to $100 to do it. I think
you're going to spend more on gas.
Yeah, I think that was one of our tips recently on the show here. It's what's your time worth? Sometimes that's how you got to make that decision.
Absolutely. So
what happens next? We serve the 5-day gets in their hands.
Yes.
You're being served. What happens next?
So you've got to give them that 5 days to pay in full. I will say, I'm just going to throw in really, really quickly, be careful of partial payments, turn off their ability to make automatic payments, have your staff on alert not to accept anything but payment in full. If you accept a partial payment, you can no longer proceed on that 5-day notice. So your options are either accept the partial payment and issue a new 5-day. Especially if they come in the office, just say, hold on, let me get you a receipt, and then go back and type up a new 5-day for the remaining balance and say, here's your receipt for that payment, and here's your new 5-day for the remaining balance. Easiest way to get that done if you want the money in hand. If you'd rather just get them out, reject anything but full payment in those 5 days.
What about people that sneak in payments? They might mail it to you or they drop it off on the weekend. Can you just return it?
Return it immediately. If it is mailed to you or dropped off, in your lockbox or something, return it immediately via FedEx so that you have a record that they received it back.
Okay.
And don't wait 2 or 3 weeks to return the payment. Return it immediately so that you can show that it was never intended to be accepted. So once that 5-day expires and they haven't paid, you're eligible to file your eviction lawsuit. So you file with the clerk of the court. The clerk has a whole e-filing system, which is fantastic. So if you are high volume and you're registered or an attorney's office like me, you can e-file. Otherwise, you go down to the clerk's office and wait in line with a bunch of paper copies and file on your own. I will say
we got to go back.
Ahead.
We got to go back. The most asked question is the 5 days. When does it start? Does weekends count? Come on, that's just this. Just for this question.
Yeah. Absolutely. Okay, so they have until midnight of the 5th full calendar day to pay, and we'll talk about holidays and weekends in just a second. So if you give it to them on the 15th at any time of day, they have the full 16th, 17th, 18th, 19th till midnight of the 20th. So you cannot file your lawsuit till the 21st. So 5 full calendar days. Weekends, it's an odd rule. And holidays. If the 5th day ends on a weekend or holiday, they get the extra day, because the idea is they can't make payment on that 5th day if they're waiting till the last day.
So if the 5th day is on a Saturday, Sunday, or holiday, they basically get one day.
They get all the way Monday. Yes, they get till midnight on Monday to pay, and you could pay on Tuesday. Back in the day, there were some judges that would say, if your 5 days falls over the weekend, even if it ends on Monday, they get 2 extra days because we're not counting Saturdays or Sundays or holidays. That's generally not the rule anymore. I I have not seen judges enforce that idea anymore. And that's definitely not how the statute is written. So usually it's just if it ends, if the fifth day is on a Saturday, Sunday, or holiday, they get one full regular calendar day till midnight to pay before you can file. So good question. That is really important. Yes.
Huge.
Yep. When I gave seminars, I used to throw out candy. Like to keep people interested and awake, I would always ask questions through my seminars, and I would have full-size candy bars and I would toss them to the people. That was always one of my questions. If you file on the 15th, what day is the first day you can file your eviction case? And whoever yelled it out first would get a Snickers.
So that's awesome. So when you file, there's what seems to be nowadays a large fee. A lot of people are like, I don't want to pay an attorney, or the attorney fees are so much. A lot of that attorney fee bill you might send isn't even your cost. Like break down the county's getting a piece, the filing fee, break down some. I think you'd be specific on the Cook County fees of what those are.
I can, yeah. So Cook County, I think right now it's $356 just to file the eviction lawsuit when the amount of rent is under $50,000. So if you're one of those landlords who have really put off your pandemic filings and you have over $50,000 on your rent roll for one tenant, you're going to be paying close to $500 to file your case. But most landlords were under $50,000, but it's still $356 to file the lawsuit. Then in Cook County, you have to use the sheriff to serve the first time around. Collar counties outside of Cook, you can go right to a process server, but in Cook County, you have to give it to the sheriff. And the sheriff is $61 per defendant, per tenant, including all unknown occupants. And you should be naming all unknown occupants on your lawsuit, because when the sheriff comes out eventually to perform the eviction and Joe is sleeping on the couch and you did not name all unknown occupants, they'll say, we don't know who Joe is and you didn't name unknown occupants, so we're not performing the eviction. So unknown occupants, and each person listed on your complaint with the sheriff is $61. So if you have one tenant and unknown occupants, it's $122 on top of the $356. So, you're up there around $800 always just getting your case filed. It's a lot because you will be using the sheriff and then generally a process server if the sheriff doesn't make service. So yeah.
Right. Real quick, how do you file? Right. Like I've never done this before. Where am I sending this? Like who?
So,
right, like what's the step?
Okay. So by the end of this podcast, I don't think any landlord is going to want to do this on their own after they hear how insane Cook County is right now, with some post-pandemic mandated procedures in place. But if you are doing this on your own, you probably do not have or do not qualify for e-filing registration. It's usually just high volume filers and attorneys who are registered. So you would actually need to take paper copies down to the clerk's office, either in the Daily Center or in one of the Cook County suburban districts, and file your case. There are instructions on the clerk's website as to how many copies you need. You need a complaint. The complaint is like the factual allegations of what happened, and a summons, which gives the date and time of the first court date. There are forms. The Supreme Court has come out with standardized forms to be used all over the state of Illinois. So it is, it's possible, and it's probably not too difficult for a landlord to file the case on their own using the Supreme Court forms, and showing up in person at the clerk's office to file it. It just gets more and more complicated from there.
I'll just add something to this. If you're listening to this and you're thinking that's a great idea, I'm going to go do that, you probably shouldn't be a real estate investor, because you're going to drive yourself crazy and you're literally stepping over dollars to pick up pennies. So I just want to make sure I'm putting that out there. It's some raw evidence of people I've seen like that are often just shoot themselves in the foot as a landlord.
Yeah.
Well, this goes back to, and I know sometimes people have a hard time swallowing their pride, but if you can get them out, even if you have to pay them, like it's easier. Like it sucks.
Yeah.
You don't, they've been screwing you over, and yet you're going to write them a check. But like at the end of the day, your business is probably in a better situation. And that's all that matters. It's not a pride thing. Is your business going to be in a better situation making this move or not?
Yep, exactly. I constantly have the business decision conversation with clients. Like, this is not about the principal. This is a business decision. Write them a check. They will get out. They filed a jury demand or whatever it might be. This is going to cost you thousands of dollars and they want $1,500 to move. Write that check.
Yeah, the amount of risk too to do it yourself. Like, I don't know, it blows my mind. I think that's a good idea. So it's assuming people are going to hire KSN, they email you, you onboard them. What do you guys need as an attorney, or I guess probably most law firms would be the same. What do you guys need to proceed for a client?
So we need the lease, a copy of the lease, the written lease, an account ledger that I can show the judge. So not a handwritten page of scribbles, really a nice account ledger would be good. And then if you served your own 5-day notice, the signed served 5-day notice. So that's it. Those 3 documents. And we generally get the complaint on file within 24 to 48 hours, assuming that there are no issues with it. And once it's on file in Cook County, I will say in the Daily Center, the suburban Cook County districts were getting 30 to 45-day court dates. The Daily Center in Chicago, so if you have a Chicago property, your first court date is going to be about 60 days out. That's way down from during the pandemic. I know it sounds horrible that you're not going to get into court for 2 months when you will have unpaid rent, but during the pandemic, we were somewhere between 70 and 90 days for a first court date. So yeah, it's a hard pill to swallow, that first court date being 60 days out. You get that back, you can't believe it, but that is the standard.
So waiting for that first court date, that's where the Cook County Sheriff is going out. What's the success rate you see? For me on the street level, I feel like it's like 10%, but what do you see like as a whole view, I guess, of them actually getting it done? It
is somewhere between 10 and 20%. Okay. I think pre-pandemic, it was 18%. Someone had actually done the math. And I had heard it was about 18%. So it is unlikely. They often make 1 to 3 attempts maximum before they return it unserved. If you get 3 attempts out of the sheriff, that's fantastic. Sometimes they will just go out one time and attempt to serve and return it unserved. So it's unfortunate. We get returns from the sheriff within about 3 weeks after we give it to them. And we've got another 5 weeks till the court date. And we're like, no, take it back. Keep trying. Like, there's more time. And they're like, nope, we're done. We made 3 attempts. That's it. It's unserved. So it can be very frustrating. Be prepared to get a second summons when you go in for that first court date. Be prepared that you'll probably have to issue a second summons and use a process server at that time. We are always prepared. We have standing orders with the clerk's office for our process server. So we don't have to appoint it each time.
So the long awaited court date comes and frankly, 90% of the time you can't do anything with it, but ask for an extension. So you could use, am I understanding that right? Am I saying it right?
Yeah, that's correct. So in January of 2021, the Supreme Court of Illinois put a mandate in place that every county has to come up with some type of mediation program in their eviction courtrooms. It was to deal with what they thought would be the tsunami of evictions because of the pandemic and a way to protect tenants who had been financially impacted by COVID. The broad stroke that they made, though, was that it protected all tenants, no matter whether they were financially impacted or whether they just chose not to pay rent because they knew that they could get away with it during the pandemic. So every tenant is entitled to this eviction mediation program. In Cook County, and it was left up to the counties how each circuit court wanted to implement it. So in Cook County, they came up with the ERP, or the Early Resolution Program, which is a misnomer because there's nothing early about it. It just delays the case by about 3 to 6 months. So when you get into court, after the case has been served, so either it's served by the sheriff or a process server, and you get into court, you've got service. If the tenant does not show up, you are still going to get a continuance. So pre-pandemic, we could get a default eviction order right then at that first court date. If we had service and the tenant wasn't there, the judge would give us an eviction order by default. That will no longer happen. We will get another continuance between 2 to 4 weeks for us to notify the defendant that there is another court date, there's another opportunity for you to appear. And And then possibly at that next court date, we could get a default eviction order. Some judges still feel bad and give one more continuance. That's if the tenant doesn't show up. If the tenant does show up once they've been served, the case is automatically put into ERP. And there's a 30-day continuance in which the tenant has an opportunity to file for rental assistance, talk to an ERP mediator, who is just a volunteer who has some training in the ERP program, but really not a lot of knowledge about the landlord-tenant relationship or even the eviction process, which is unfortunate. And we find most cases that go through ERP, the ERP program does not resolve anything any more quicker than we would be able to resolve it if we could negotiate directly with the tenant. Most of our landlords have always been open to payment plans, extended days for move out,